The civil procedure problem from July of 1996 is a very straightforward Civ Pro question. It also lends itself to organization before you even read the fact pattern. Take a look at the call of the question. This is a very useful call, one that allows us to organize our thoughts quickly. 1. Assuming the defendants were properly served, did the state court properly assert personal jurisdiction over each defendant? Discuss. Well, this is pretty easy. All we've got to do is have a separate section for each defendant. You've got to cover the long-arm statute or assume its existence, and then for each one, we talk about personal availment, foreseeability, and fairness. That's it for each one. We can organize our thoughts to the first call of the question without even reading the fact pattern. Next, look at question 2. Is the federal court judgment a bar to any of Pat's claims against either defendant? Discuss. Well, we will look at each defendant and we will consider res judicata and collateral estoppel. It really is that simple. So, our real job here is going to be connecting the facts from the pattern to elements of our legal analysis. And we're going to see just how straightforward and comparatively simple that process can be. So go to the top with me and let's briefly review the fact pattern. In paragraph 1, we meet Danco. D for defendant is a pretty good hint. They're incorporated and headquartered in state Y. Pat is a state X resident. Pat has been employed in state X as a state X salesperson from 85 to 95. In 94, Tom, a state Y resident, was hired as a Danco's sales manager. Tom works at the Danco headquarters in state Y. Well, I think it's reasonable to make a little graph indicating the two different states and which parties reside or work in which areas. We always need to find a home for those facts, just like most other facts from essay problems. In paragraph 2, in 1995, this new sales manager increases sales quotas and exerts pressure to reduce lead times between contact and sale. Pat, our plaintiff, protests that this will ruin long-standing customer relations, and his pleas are ignored. Pat doesn't meet the new sales quota. They fire him on his 50th birthday. Well, we anticipate an age discrimination suit, and in paragraph 3, we learn a little bit more about possible damages suffered by Paul. He has several large deals pending at the time he is fired. He is promised a commission for any of those sales that are completed, and Danco quits doing business in state X, and the sales weren't ever completed. Okay, we go to paragraph 4, and here we've got a federal lawsuit filed by Pat, which is referred to in call of the question number 2. So we look to see what is adjudicated here for purposes of past adjudication in the state litigation that we anticipate will follow based on our close reading of the call of the question. So he's suing in federal court for age discrimination and for breach of contract. And the district court grants a summary judgment motion brought by the defendant on the age discrimination claim and dismisses the contracts claim for lack of subject matter jurisdiction. Okay, so they don't even hear the contract matter at all, and we move on to paragraph 5. Here, Pat learns after the federal litigation that a couple of possible state X employers have refused to hire him because of bad job performance references that were provided by Tom, the comparatively new sales manager. So now Pat sues both defendants, Danco and Tom, in state X for age discrimination under state X law and for breach of contract and defamation. Okay, so those are his 3 claims, and we're going to have to analyze each one of them with regard to each defendant in part 2. Next, we've got special appearances by Tom and Danco to quash. The court denies those motions. We're going to find out that this denial was correct. The defendants then answer and file motions for summary judgment, claiming the federal judgment as a bar to the current case. The court denies those motions too, correctly, as we will conclude. Then we've got the long-arm statute in the last paragraph and the calls of the question. So, as I promised, this is a straightforward fact pattern. The issues are easy to spot, easy to organize. And that gives us a chance to work efficiently and focus our attention on factual analysis. And compared to our competitors, those candidates on the exam who are not well prepared to organize an outline, we have a tremendous advantage. So take a look at the outline of issues that I present, and you'll see we don't have to go much beyond what we were able to do at the time that we read the call of the question. There's not a whole lot of extra detail that needs to be analyzed. So, with regard to the first call of the question, on state personal jurisdiction, you'll see I've got a separate section each for Danco and for Tom. I include a very brief reference to the long-arm statute, and then I go into the elements of minimum contacts, each in a separately headed paragraph. Then I reach a conclusion as to each. Then we turn to the second call of the question, the one asking about past adjudication. And here, you'll see internally, I have a separate section for each of the two defendants, and for each of the theories of liability as applied to each defendant. Once again, the organization here is about as simple and straightforward as you can possibly hope for. This is a question that lends itself to basically be a showcase for all of the methods that we've been working on together for the last little while. So, briefly, take a look at my answer, and let me offer a few highlights for your perusal. Notice up front, I lead with the facts in my first paragraph. I explain the procedural status of the case, and up front, I allude to the conclusion. This is not necessary, but I think you'll agree that in the context of this answer, it makes everything slightly easier to follow. And our goal here is to make it easy for a disinterested grader who is working quickly to see that we know what we're doing, to see that we're hitting the issues, analyzing reasonably carefully, and arriving at conclusions that flow from our analysis. So we turn to Danco. Notice again under Danco, I lead with the facts. I explain who Danco is, and I set up the burden that Pat has to make in order to show that the state X court is an appropriate forum in which to bring his claim against Danco. So I talk about the long-arm statute, and here you can see I actually pause a little and go into some greater depth. This is a straightforward question, and I think that gives us a chance to put in proportionately more law than is present in many of the other answers that you have read. But I don't really spend a great deal of time on the law. You'll see mostly I am analyzing the facts. Then I move on to minimum contacts, and here the analysis with regard to Danco may be a little bit more elaborate, but only because we have more facts to deal with and to find homes for in the analysis. Still, I think you will agree that the format that I'm using here is very useful. It helps us organize our thoughts clearly, and it allows us to really analyze the situation and arrive at a specific conclusion. The state court properly exercised jurisdiction over Danco. So, now we turn to the analysis with regard to Tom. Again, I lead with the facts. I explain who this guy is, and then I move into the analysis. The framework of the analysis is identical. The content of the analysis is a little different because the facts surrounding Tom are not identical to the facts about Danco. Still, ultimately I reach the same conclusion, which is that the state X court properly exercised personal jurisdiction over this defendant, Tom. Next, we move into the section that I actually think is a little more interesting. Here, we actually have to do a little bit of thinking and then show it under time pressures. So, we ask the question, is the federal court judgment a bar to Pat's current claims in state court? We focus first on Danco. Notice that up front, I lead with the facts again, and I'm focusing very quickly on the procedural status of the case, where the summary judgment motion had been granted in federal court, and the impact of that grant on the instant situation. I conclude that the state X discrimination claim isn't barred by the federal litigation because it arises from different law. Now, it's possible that elements of this claim might be barred by collateral estoppel, but we don't know enough details to be able to decide that conclusively. Certainly, res judicata is not going to bar this claim in its entirety. Next, we turn to the breach of contract claim, and here we never had a final judgment from the federal court at all. So this claim is basically new in the state litigation. Certainly it has not been previously litigated. And then when we turn to defamation, this is a brand new claim. The theory of liability arose after the federal litigation had been ended. Consequently, neither res judicata nor collateral estoppel could conceivably bar this claim. Now, we turn to Tom, and it's apparent that he wasn't a party to the earlier litigation. But he's probably a privy. And you'll see, I don't have separate sections under our analysis of Tom for each of the claims. I suppose it wouldn't have been very hard to do it that way. It might have made the answer slightly longer in terms of the number of pages it covers, but it wouldn't have substantially changed the content. So if you broke this part of the analysis up more than I did, no problem. I think it's fine. But for our purposes, and as I wrote my original model answer under timed conditions, it seemed to me that it would be adequate to handle the past adjudication issues about Tom all in one paragraph.